Yes.
May it please you, my lords, I appear on behalf of the appellant with my learned junior, Miss Donegan, and my learned friend, Mr. Southgate, appears on behalf of the respondent to the appeal. My lords, beginning with the ground one, if I may, and the issue of the conduct that we say was not properly taken into account by the judge. If I could invite you to turn to the authorities bundle.
So you're just going to, your submission is just going to follow through your grounds?
I'm going to take them, so I'm going to take, first of all, the issue of the conduct, then yes. I'm going to take the issue of the settled loan, then I'm going to take, lastly, grounds 4 to 6.
Right.
So if I may, I'm going to deal with it in that order.
Thank you.
So beginning with, if I could take you to the authorities bundle at page 14, which is the case of Petskoff. Mr. Justice Peel says paragraph...
Wait a minute, 14... Sorry.
Authorities bundle.
Nope, sorry, wrong one. Yes.
Mr. Justice Peel says here at paragraph 46 that conduct must be pleaded at the earliest opportunity, that it must not appear by the back door, and if you scroll down to 15, the overriding objective states that it should be pleaded at the earliest opportunity. In this instance, the first appointment took place, so if I could ask you to turn to the main bundle to the chronology.
I'm sorry, I think I'm behind. I didn't catch up with you, I was on the wrong page. Which paragraph?
So beginning at paragraph 46, little one.
Sorry, yes.
Conduct is a specific 25 factor and must always be pleaded as such.
Yes.
It cannot appear by the back door. And then in paragraph page 15.
Well, I thought you were relying on Little Roman 2 at G, earliest opportunity.
The earliest opportunity. And I wanted to address that because the sale of Elsa took place after the first appointment, and therefore the earliest opportunity to raise it was in the post-FDR directions. And so if just dealing with Setskova, you'll see that at paragraph 43, conduct must prove the facts relied upon if those facts meet the conduct threshold, and there must be a negative financial consequence to that conduct. If stage 1 is established, this is paragraph 44, the court will go on to consider how the misconduct and its financial consequence should impact upon the outcome of the financial remedy proceedings. And specifically at 46, little 1, if it's not pleaded, it's inappropriate to rely on conduct through the back door. And in relation to the chronology, which you will find in the main bundle at page 57, you will see that the first appointment took place, the first appointment took place on the 7th of November.
Sorry, of which year?
2022.
Right.
And if I could ask you then to scroll down to page 59, you'll see that in May of 23, the husband is repeating his requests for disclosure of all interests in the sale of Elsa. On the 8th of June, the wife asserts that she signed an NDA the night before which prevented any disclosure. On the 4th of October, at the bottom of 59, D.J. Smith ordered that she should provide disclosure, and at page 60, on the 14th of December 23, there is the completion of sale of Elsa. And on the 1st of May 24, there is the order of Deputy District Judge Todd, which provides that the wife should answer the allegation made by the husband. And whilst that order is not in the bundle, if your lordships could kindly turn to 296 in the main bundle, the core bundle. At paragraph 1.1, the wife sets out there the allegation that she must meet, which was recorded on the face of Deputy District Judge Todd's order, particularly that the sale of Elsa was structured so that the value of the consultancy agreement does not form part of the consideration of the sale and therefore the assets of the family for division, and is instead presented by her as future post-marital income. If I could then ask you to look to the same in the core bundle at 114. At paragraph 3, the judge identifies 4 lines down, having signalled his position during the case management stage of the proceedings, the husband seeks to demonstrate that the wife's conduct in relation to the sale of Elsa should also sound in the distribution of the matrimonial assets. And if I could then invite your lordships to turn to the authorities bundle at 382.
We have two, well, I do. I have 2. So can you give the tab number as well? You have it. Is that 1 to 8 are in the first bundle, and 9 to whatever it is are in the second?
Yes, I'm sorry.
Don't worry. It says 382.
382.
The authority is
the authorities bundle. Because I'm electronic.
Of course you are.
I don't have.
It'll be in the
tabs.
second, because number 9 is 228 on.
Thank you. So wait a minute. What page?
This is 382 of the
Thank you.
authorities bundle. This is citing Mr. Justice Moore in MAP and MFP, and this is Mr. Justice Peel in HO and TL.
No, not 384.
No, it's a case called AF and GF.
AF and GF, forgive me. The reason I'm relying on it is just to cite what Mr. Justice Moore says here.
Okay.
Arguments regarding ABBACs come down to an issue of conduct under section 25(2)(g) of the Act, namely conduct that it would, in the opinion of the court, be inequitable to disregard. Such conduct must be gross and obvious for the ABBAC to succeed. The court must be satisfied of wanton dissipation of assets. Could I invite your lordships then to turn to the supplemental bundle particularly to 157.
Yes.
And at G,
No. What is 157?
it is the in the supplemental bundle. It is my closing submissions.
They start at 159. Give us the internal page of the.
At internal page 8. Sorry, 158.
8 is 166. Internal page 8.
Sorry, forgive me, my lord. If I could ask you to look at internal, top of page 7 of internal page 7.
Right.
My learned friend cites in his skeleton argument my analysis of section 25(2)G, conduct within the marriage. And I am doing so not in relation to the wife's conduct, sorry, not in relation to the husband's conduct, but in relation to the wife's conduct. Does her allegations of conduct surmount the high hurdle? And I submit that they do not.
I think you slightly misspoke. What you're saying there you were dealing with the wife's allegations against, conduct allegations against
My client.
and you can see that from the previous page.
Exactly.
On page 6. Going to determine, you're going to determine whether or not the wife has met the high hurdle.
Exactly. But at one...
Sorry, hold on, can I just...
Sorry.
Right, okay, yes.
Then at 164...
Back a page.
Internal page 14.
Internal page 14.
Internal page 14.
Give us the internal page because the electronic are obviously way out.
I deal with the wife's non-disclosure at G. Starting at F. Having complained to you of secrecy in which she did...
Wait a minute.
Sorry.
This is internal page 14.
Internal page 14 at F.
Oh yes, complained to you of secrecy. Yes,
In which she did the Coulson deal for mutual benefit, even though it was in the press. And so all the time she's not telling us anything. We're asking, it is disclosable. Let us be clear, it is disclosable. She has an expert team, different team at that time, but an expert team. She well understands you have to tell us and why, because we may have a view about it. And at the next page, internal 15, E, but the reason we want to know is we knew that the wife was not going to tell us, but the district judge gave her the opportunity. He gave her the chance to set it out in a statement and attach such documents that she saw fit to prove her case. And if I could ask you then to scroll down to internal 16 at H. I suggested to her, and this is in relation to the consultancy agreement with Mr. Snyder, I suggested to her that if the husband had done the same, she would have said that it is a dishonest transaction. And she would have agreed, and she agreed, because patently it was a dishonest transaction. Whether or not Mr. Snyder is owed the money from the wife, or whether or not the wife would prefer Mr. Snyder to have the money than her husband the money, he is a director at the club. His job is to further the interests of the club. The club decided to sell itself, and he was approached by Miss Kang. You do not pay over 1 million. Least of all, they have got transcription's not exactly accurate. They have got the husband sitting there saying, I will step back in if you want. I would like to become a director again in order to assist you at this time. And she accepts that this is a man who is cognizant of large share transactions, and self-evidently he is. So the payment to Mr. Snyder does not make any sense, and as I put it to her, is dishonest. And at 169G, sorry, internal, so forgive me if I just deal with one more point, at internal page 18, I addressed the tax. At A, she would simply prefer to give it to the taxman than her husband. That is the nature of Mrs. Rosemin-Culligan. That is what she has done. That is why we are all here, because she entered into a deal for the sale of her club that she knew was a partnership she had entered into with the husband, with him funding it, all in her name, with the control. She refused what she was doing, inaudible, but to disclose what she was doing. We had to go to court to get to DJ Smith, who endorsed the undertaking that we had offered months earlier and said, you have to show. And then at the bottom of the page at G, so internal 18, that in my submission is conduct, that it is inequitable to disregard. And I'm going to come back as to how you should treat it, but I accept that you are in this position because of her misconduct, and the monies are now due to the taxman, and there is nothing that I can do about it. That is 1.28 million, whereas it should have been 400,000 in tax. And then if I could ask you then to turn to 17.
So the difference in tax was said to be roughly 800,000.
It was a million.
It was was it?
It was a million.
Okay.
And found to be a million by the judge.
Right.
And if I could ask you then to turn to 177, internal 27.
Internal 27.
Internal 27.
Hold on. Yes.
And in my submission, what the wife
Where
was,
are you?
sorry, at E,
Yes.
what the wife was doing was oppressing the husband by not allowing him disclosure of the deal that she was doing, and then doing a deal which leaves him down, and therefore you can see the financial consequences of our actions. Yet the readjustment that I ask you to make is only 200,000. In the scheme of this case, it is an extraordinarily balanced and rational position for the husband to adopt. If I could then ask you to look in the core bundle. At 121.
Sorry, give me the page again.
121, my lord.
121.
121.
This is in the judgment.
This is in the judgment.
Which paragraph?
Paragraph 27.
So that's page 120.
120.
Starts at 120 anyway.
The wife, this is the 5 lines from the bottom,
Okay.
lines from the bottom of the paragraph. The wife accepted in cross-examination that, despite being given an opportunity by the court to do so, she did not provide to the court any documents dealing with the negotiation of the consultancy agreement. The wife further accepted that she had incurred an additional 1 million in tax liabilities by entering into the consultancy agreement, which is subject to income tax rather than incorporating the consultancy fee as part of the sale price. And paragraph 28, the purchase and sale agreement entered into by the wife also provided for a 1.1 million fee for Mr. Snyder, who, as I have noted, was a director of ELSA. The wife conceded that Mr. Snyder was also a friend. In the documentation that is available to the court, that payment is variously described as professional fees and a commission. In cross-examination, the wife agreed that Mr. Snyder was a director of the club, in any event under a fiduciary duty to advance the sale once it was agreed. She further accepted the proposition that if the husband had paid a friend 20% of the total consideration for the sale of Settle Limited by way of a consultancy fee, she would probably have accused him of dishonesty. Finally, the wife acknowledged that the additional 1 million of tax liability incurred due to the structure of the ELSA deal and with the fee to Mr. Snyder, the sale of ELSA had cost the family economy an additional £2.1 million. If I could then ask you to look to paragraph 29. At the bottom of the paragraph, third, the husband's alleging that the ELSA deal was a construct to defeat the husband's sharing claim or his post-marital income. Third, whether the additional 1.1 million fee to a director who was in any event under a fiduciary to sell the club was legitimate. Once again, I will deal with each of these disputes so far as is necessary when I come to the question of computation and distribution. And then if I could ask you to turn to page 137 of the same bundle. At paragraph 67.
Yes.
Bottom of the paragraph. Having regard to the totality of the evidence before the court, I am satisfied that the consultancy fee of £750,000 per annum over 4 years paid to the wife under the consultancy agreement that accompanied the sale of ELSA constituted deferred consideration for that sale of that company to YMK Holdings. In paragraph 68, notwithstanding that the parties were in dispute regarding their matrimonial finances during the currency of negotiations between ELSA and YMK Holdings, the wife's firm criticism in these proceedings of what she asserts has been the husband's lack of transparency in relation to the deal with Kalendi and the historic involvement of the husband in the management of ELSA, I am satisfied that the wife showed a marked reluctance to provide information about the negotiations of the sale of ELSA. And then at paragraph 70, halfway down the page, the paragraph, within this context, whilst DDJ Todd refused on the 1st of May to grant the disclosure sought by the husband of the documents associated with the negotiation of the sale of ELSA, the wife, DJ Todd, did direct the wife to file and serve a witness statement in response to the husband's allegation that the sale of ELSA was structured to ensure the value of the consultancy agreement did not form part of the consideration of sale. As I have noted, the wife accepted in cross-examination that, despite being given the opportunity by the court to do so, she did not provide the court any further documents dealing with the specific allegation with respect to the deferred consideration. The court is therefore limited to considering the documentation set out above. I am satisfied that the documentation supports the husband's case. And at paragraph 73, I am also satisfied that the wife's assertion that the consultancy fee totaling 3 million constitutes income and not consideration renders the deal or the ELSA financially disadvantageous.
Sorry, where are you?
Sorry, forgive me, paragraph 73.
73, thank you.
renders the deal for the sale of Elsa financially disadvantageous in a way that is inconsistent with the wife's case that she is a highly experienced pioneer in women's football, responsible for the building of the club from scratch. Then the next sentence, the sale agreed by the wife results in her paying as much higher rate of tax on the monies received under the SPA and accompanying consultancy agreement than would have been due if the total of 3 million under the latter had been expressed as part of the sale price. The wife accepted in cross-examination that she had incurred an additional 1 million in tax. And then the last line of the paragraph. Further, and in the same context, on the face of it, it is difficult to see why the wife would have agreed to an additional 1.1 million fee being paid to Mr. Snyder, a friend and director who was under a fiduciary duty to effect the sale. And if I could then ask you to move forward to page 139 at paragraph 76. It was advanced by Mr. Thorpe in his closing submission that should the foregoing findings be made, because of course I was not in a position in my opening document to rely on findings that had not yet been made, the court having already determined that the issue should be dealt with in cross-examination rather than by pleadings of points of claim and defence. And in any event, in my submission, it would always require the cross-examination to take place. But you will see that should the foregoing findings be made, a fair recompense for the consequent diminution of the matrimonial assets would be to allocate to the wife the 750,000, allocate to the, he says to the wife, but it was to the husband, the 750,000 deferred consideration entirely to the husband's side of the settlement. I am, however, satisfied that in addition...
Satisfied.
Sorry?
Not.
Oh,
Just
sorry.
You missed the not.
Forgive me. I am not, however, satisfied that in addition to the total consultancy fee, net of tax, in the sum of 1.6 million added to the wife's side of the asset schedule, the husband should be further awarded the totality of the deferred consideration in the sum of £750,000.
Can you just remind me what the deferred consideration was part of the
part of the 6 million, effectively.
Right, was just
so
called
750,000 was deferred for, let's say, a 6-month period. It may have been a 12-month period to tie up any monies that may have been owed one way or other.
Now, there, your submissions are recorded as being that 750,000 should be allocated to the husband. When you took us through the transcript, the sum being referred to was 200,000. I thought
the net effect was 200, but the 700. So I asked for 750 to be transferred across.
Right. Okay.
I can find that for you on the transcript or my. One in the transcript, it is internal 20. For our numbering, it's 17. Sorry, wrong bundle. For our bundle, it's 178, but I suspect that's wrong for yours.
No, it is 178.
And
yes, I see. Rather than share the final 750, that is payable on deferred consideration. That should be paid solely to the husband.
That should be paid solely to the husband. But the net consequence, once you would only be £200,000. And in my submission, the judge, when determining how he should, in exercising his discretion, whether he should accept my submission or not, took account of open offers, which were not relevant because, of course, they were pre-cross-examination and pre my proving that the tax had been incurred unnecessarily and that the payment to Mr. Snyder made no sense and was prima facie dishonest, which the wife accepted. So in those circumstances, for the judge to discount my submissions by reference to the open offers was to weigh into the balance of the exercise of his discretion something that was not relevant, and to fail to take account of the fact that this was conduct, it was pleaded, and the reason why the husband submitted that the amount that should be limited in that way was because of the needs of the parties being approximately £5 million each. So if I could ask you to internal 27
Internal 27 of what?
of the transcript. At H. We decided not to apply it, the add back argument, because if you add back, and that would have a significant impact on the wife. So we've considered how to present it to your lordship, and we have, on reflection, recognising that this is a 40-year marriage, and recognising that the wife has needs, just as we have needs, have asked you to make a token adjustment. But it is only a token adjustment because the real cost to this family is in excess of 2 million. And if we're asking for an adjustment of 200,000, just 10% of that.
I know you've referred in your submissions to the 5 million as needs. I haven't, speaking for myself, quite understood
How I got to that number.
because the judge doesn't address.
He doesn't address these. I'm going to come on to that.
You're going to come on later, are you? Deal with it when at some point. No, just because it.
But well, I'll come on and deal with it.
Okay, thank you.
Internal page 19.
Sorry, with the transcript still, are we?
Transcript, because Moylan Jr. has found it for me.
Oh.
At little f.
Yes.
And it's a construct that cheated us of significant funds, and the only reason we're being so magnanimous in how we present it is that we are forced into such magnanimity by the fact that the tax is due and by the fact that both parties need approximately 5 million plus to meet their needs.
I understand the figure. I was wondering what the breakdown of the 5 million is. Because we don't have the Form Z, do we?
You don't have the Form
No.
Z.
So, and I don't think we have the submission. So I don't know what the parties' or we don't know what the parties' respective cases were on housing and income needs.
I'm going to come on to that as my next point.
Okay.
Can I just, before I do, remind your lordships respectfully of the reason why we were saying that needs trumps conduct is relying in part on Vaughan and Vaughan, in which Lord Justice Wilson, when talking about ABBAC, says, this is 2008, 1 FLR 1108.
It's not in the bundle.
Not in the bundle. The only and obvious caveats are that notional reattribution has to be conducted very cautiously by reference only to clear evidence of dissipation in which there is a wanton element, and that the fiction does not extend to the treatment of sums reattributed to a spouse as cash, which he can deploy in meeting his needs, for example, in the purchase of accommodation.
Thank you. Yes.
Can I move on now just briefly to deal with the settle loan? I know it's a minor point, but it ties in to 2 points on the asset schedule. In the
So we're
supplement,
moving on from ELSA.
I'm moving on from ELSA. My point in relation to ELSA is we pleaded conduct, we said how it should be dealt with, and the judge, when dealing with it, took account of something that was irrelevant, namely our open offer, and felt that, and asserted that it was sufficient just to have added back in the money that the wife had, but was seeking to exclude as income, namely the 1.6 million, and didn't deal with the missing 2.1 million, which would have been in this family's economy. And that, in my submission, goes to not just the issue of conduct, but also how to treat housing need. On the settle loan, in the supplemental bundle at 132,
So can you remind me which grounds of appeal is this? Is this ground 7?
this is ground 7.
Sorry, the supplementary bundle page.
132, my lord.
Is this the table?
This is the table, and you'll see that this is my asset schedule, and the settle loan is there shown in yellow. It doesn't appear in the additional column, in the columns of the parties, because I am proposing that it should, if ever repaid, be shared equally between the parties on repayment. And I make that submission at 170 in the bundle.
Internal page.
Internal page 20 at A. My learned junior thinks it's 178 for you, but internal 20 at A. The settle loans provide for, in the event that they are repaid, for that to be shared equally, and my client will honour that. And I point out that in my submission he is an honourable man and that he can be relied upon to do it.
So your total for investments and policies was 8,182. Figure at the top of page 132. Is that right? I haven't netted the sums, but
Yes, so that if we go to my Miss Faginato's totals, you'll find those at page.
yeah. Sorry, it's too small, that one. Have you got the bigger one? That's the bigger one.
139,
Yes.
and you will see that there. So this, I'm combining the 2 points really. There, my learned friend, the number is 427706, and my learned friend, Mr. Southgate, says, well, that's where the judge got his number. And my complaint is that our number, it's not totaled in there, but it would have come to 217,342. You see where it says naught next to the 427? If you correct that error in the Excel,
Sorry, wait a minute.
Where are we looking?
sorry, we are looking at page 139
Yeah,
under the policies.
right.
Yes.
I, in my clarification sought of the judge, said to the judge, post his draft judgment, where did you get the figure 427706? Please clarify. And he didn't. If you, where it says naught next door to 427, if you put the sum in the Excel for what we say our policies were worth, it comes out at 217,342. So
2173. So it's not naught.
it's not naught.
How does that compare then? Sorry, I'm not following at the moment. If 132 the total you had there for investments in policies excluding the settled loan was 8182, isn't it?
Because
Have we got that right, or is the figure at the top, not at the bottom, isn't
it's
it?
in at 132, it comes out at 373924. But
No, that's the business does it?
no, investments policies. But it includes the WISE investment, and it includes the wine and bonds. So our presentation was slightly different.
I see.
So he dealt with the wine and bond separately.
So you're saying if you were looking at the equivalent, your figure, the WISE figure of 427706, yours would have been 217342.
Exactly. And so the combination of
Wait a minute. But the two, neither of those figures include the settled loan.
Neither of, sorry, let me go back to Ms. Faginato's figures. Neither of those figures include the settle loan. And so we say that the investments and policies, the comparison is really 427,000 as against 217,000.
Can you help me as to where on the wife's schedule the settled loan appears?
My learned friend's telling me it's the next section down.
Under business interests.
Under business interests. There it is.
Okay, I see. Yes.
We posed the question of the judge. Please,
Hold on. Can
sorry.
I just hold on a second? So if we look at the, I just want to look at the judge's schedule while you're.
So the judge's schedule is
Page 151. So the judge took the figure for your investments policies at 427706, and you said your case was that it was 217312, 342. And so far as the business interests,
on the first, in his draft judgment, he had them the wrong way round. We pointed that out, and he swapped them around.
you mean the 427 and the 125?
The 427 and the 125.
Right.
And part of the clarification we asked him was, please explain the 427.
And he didn't.
He didn't.
I understand that. But what I'm trying to look for is that the settled loan is included by the wife under business interests.
Yes, and it appears in his lordship's table
Separately.
And he puts it into the husband's column.
Is there any significance that in the judge's table it's labelled settled loan and WISE EIS? Do we need to worry about WISE EIS?
Not particularly. My client made an investment through the EIS scheme of £25,000 in the year preceding the hearing, and like the settled loan, it is also being an EIS investment, not particularly realisable.
Okay.
And so that's why I think they're grouped together. But the point from my client's perspective, my learned friend says this is de minimis. The combination of the 2 points are £350,000 for my client.
But can I, because I haven't fully appreciated this reading the documents, your first point is that the judge has taken the 427 rather than the 217 without explanation.
Without explanation.
And the second point is, so he hasn't double counted the settled loan.
We didn't know that when I wrote the skeleton argument because I was waiting for the clarification to come back.
Okay, so but you're saying that the settled loan is, it probably ties in with your larger submissions in respect to Kalendi, is uncertain.
It's uncertain, and the fairest way to deal with it would have been to share it. Those were our submissions. He didn't deal with them, and he didn't deal with the clarification point. And the idea that it's de minimis, it represents £350,000, and that represents 10% of my client's liquid capital. So my learned friend's assertion that it is de minimis in the scheme of the total assets, including Colendi, which we also say is illiquid, doesn't answer the significance of the point for my client.
So would it be fair to say that in some respects it's linked with your overall challenge to the judge's distribution of the liquid illiquid assets?
Yes, to that, and to being irresponsive to the husband's submissions generally. Because in relation to conduct, he was not responsive to our submissions. In relation to the request for clarification, he was not responsive. And in my submission, he was not responsive when pressed on the question of needs, which is where I now wish to...
Do we have in the documents the request for clarification?
Yes. Could I ask you to... well, when I say you have it in my skeleton argument.
As I understand it, correct me if I'm wrong, we don't have the draft, and we don't have the request for clarification itself.
Not the request for clarification itself. What you have is the quote set out in my skeleton argument.
Paragraph.
Forgive me. I think it's SB.
Wait a minute.
Sorry.
With your skeleton argument for the appeal?
The skeleton argument for the appeal. 34 of the core bundle.
So it's the emboldened bit. Please clarify how the court arrives at 427706.
Yes.
Right.
And was there any separate request for clarification, or did you not then know about the way in which the judge had treated the settle loan? In other words, by just allocating it to your client?
Save for the fact that we know there's no separate clarification on that point.
Okay, thank you. Yes.
Turning now to the question of needs, which is grounds 8, 10 and 11. Could I invite your lordships to look to core bundle at page 144. Paragraph 90. In the foregoing circumstances, I consider that housing is the primary capital need for each party at this time. During the course of his evidence, the husband evinced an intention to move to the United States to build a home on the land he purchased in that jurisdiction, and gave oral evidence that this would come at a cost of $2 million. In my submission, that wasn't his evidence. In the core bundle at page 329, at paragraph 38, also in 2021, after struggling with the separation, having to forego my involvement in the renovation of the house, meaning the family home, I thought having a project of my own would help. I bought a property in Atlanta, Georgia, in my sole name for $525,000 with the intention of developing it. I'm yet to carry out any works on it, as I cannot afford to do so given the funds expended in the family home and poured into Elsa. But I still intend for it to become my project once Diane and I have achieved financial disclosure. And then at 342 in the same bundle,
Yes.
at 95, my needs are for housing and to meet my living expenses in retirement. I attach it at page 19 to 20, updating property particulars of properties that would meet my need. I consider that with myself and Diane's housing needs are the same for a 3-bedroom property in North London with, I stated a need of £7,500 per month for myself in my Form E, and that remains accurate. And then if you if you then turn to 349, you'll see examples of properties that he put forward essentially for himself and for
349. My bundle.
Sorry.
346.
346. Sorry, forgive me because it's an overprint. I misread it.
So that's Ripplevale Grove, yes?
Exactly. There are 2 properties there, one in Almeida Street and one in Ripplevale Grove. He also explains that he was caring for his father who was living with him in a rented accommodation.
The judge, taking us to the judgment, the judge said during your client's oral evidence, do we have a transcript of that part of his oral evidence?
It's not in the bundle.
Right. Is it available?
It is available. My lender junior will hunt it out.
Because your submission is that was not his evidence, but it's the oral evidence which the judge was relying on, not the written evidence.
We will
So
check the point over the shorter term.
Okay, thank you.
And additionally, his evidence in his section 25 was that he was effectively caring for his father by living with him in rented accommodation. And therefore the possibility of moving to America is clearly not viable.
So their housing need is set out and the income need is £7,500 a month.
£7,500 a month.
Thank you. Right.
Sorry, can I just... There seem to be 2 different points here. And I just want to clarify. So, one is the question of the cost of the American property, including projected future expenditure, as to which, as my lord points out, there's the question of what was said in the oral evidence. But you've made a distinct point, which is your client is caring for his 90-year-old father, ergo he can't move to the US.
Yes.
That seems to be a completely distinct point.
He has set out his needs in his section 25 statement. I need a property in North London with 3 bedrooms and I need an income fund because, as he says here, paragraph 92, where if we start at 91, as regards income, my only income currently is a share of rental income. I'm 61 years old and have had a career in financial services and technology. The last salaried job I had outside a company I had set up in was in 2005.
Well, to be sure, but I'm sorry to cut you off.
Not at all.
But if I could just focus on the question I was asking. As I understand it, what you're relying on is what he says in 95 read together with 96, which is there's a need for a housing in London and a reason given, viz. He's looking after his 90-year-old father who's living with him.
Yes.
So it's a combination of his own housing need together with his father who he's caring for.
Yes, his father. The fact that he was carrying his father for his father. That was the status quo at the time before the judgment.
Yes.
The issue of America was a distraction. It was a project that he had invested in, and he described it as a project. And we say the judge was wrong to to cross-pollinate that with his housing need. His housing need was as set out in his Section 25 statement. And if I could go back to the judgment at page 144. Sorry, it's paragraph 92. As I have said, the obligations in this case include a substantial US tax liabilities in addition to tax liabilities in this jurisdiction. Last line, I am satisfied that to achieve fairness in this case, the husband will need to have left over a sum for securing housing after having settled his share of his liabilities. And in my submission, that was plainly wrong. His needs were not only for housing, but for income. And if I could ask you to turn in the bundle, the authorities bundle, to page 218. Where my Lord Justice Moylan, in Waggett and Waggett.
Sorry, hold on, behind you. All right. You give the page number again.
Sorry, it is at page 218.
Thank you.
Paragraph.
Ultimately, I'm going to conclude at paragraph D because that is the crucial bit.
Paragraph.
D. Sorry, I've got it in lettering on the left-hand side.
Well, paragraph 108.
Sorry, I'm on page 218 of the authorities
Yes,
bundle.
paragraph 108.
Paragraph 108.
Yeah.
That's what I wanted.
Sorry, my lord, I was being dim. At little d, these comments would require, and in my view, practical justice would dictate that there must be a means of determining whether, and if so, how, the sharing award does or does not meet the applicant's needs. This inevitably also requires the court to determine, in the individual case, how the sharing award is to be deployed to meet needs. Absent the court considering this latter issue, there would be no way of assessing whether the sharing award met needs. In my submission, the learned judge did not conduct that analysis, and it was wrong for him to find that his only need was capital need for housing. He does so on the basis of earning capacity, and this is in the core bundle at 144 at paragraph 89. And this criticism is equally applicable to the wife as it is to the husband. 4 lines down, he says, with respect to income and earning capacity, both parties have, in my assessment, reasonable prospects in this regard. And if I could ask you to look down in the paragraph to approximately 7 lines up, he is 61 and continues to work in the field of fine tech. Whilst he is at present not drawing it, he has a contracted salary with Coulson of 300,000 gross per annum. As I've noted, the single joint expert opines that it is not unreasonable to assume that the husband may receive this contracted salary if Colendi becomes sufficiently profitable. My first point is age 61 and 63, it is irregular to assume an earning capacity for the rest of their life. And you've seen the husband's evidence that he had not been salaried for 20 years, save for the 3 years when Settle had the funds to pay him a salary.
Is the judge right in saying that the husband had a contracted salary with Colendi?
No, I'm going to come on to that point.
Okay.
He's wrong about that. And I'm going to take you to the single joint expert's evidence. Could we go in the core bundle to 218? At paragraph 4, at the bottom of the page, Settle remains loss-making and is yet to become cash flow neutral or positive. However, should Settle become sufficiently profitable in either 24 or beyond, I do not consider it unreasonable for Mr. Culligan to receive his previously contracted salary of £300,000. Then if I could turn you on to page 233 in the same bundle. At paragraph 2.43, as I explain in my report, it is difficult to estimate reliably Mr. Culligan's sustainable income from Colendi based on the information available to me. However, I consider it possible that Settle will become cash neutral or cash generative for Colendi in 24, and once sufficiently profitable, I do not consider it unreasonable for Mr. Culligan to receive his previously contracted salary of £300,000. So possible, not probable. And at 282 in the same bundle. 282 of the same bundle. At the bottom of the page, subparagraph 4, Settle.
I'm sorry, I know you've given it twice, but I've somehow lost the place already. Could you give me the page again?
282, my lord.
Thank you. Sorry.
Sorry, the date of the first report was October 23, and this is October 24.
This is October 9th of October 24.
And he was previously saying that. Sorry, what was the middle one? The middle one was November.
March 24 was the.
That was page 233 is November 23, and that was it was. He said it's possible that Settle will become cash neutral for the year 2024. I assume that's the accounting year, not the financial year.
I'm just troubled by the date, my lord, because at 234, it appears to be dated 8th of March 24.
That's the Grant Thornton.
Sorry, forgive me.
Okay, but anyway, it's by the time we get to October 24, Settle is still loss-making.
Still loss-making, and he says at. Sorry, I've lost my.
It's 4. I'm not able to determine, based on the information available to me, when it may become profitable.
Exactly. So in those circumstances, the single joint expert, A, was not referring to Colendi, B, was saying he could not say when it would become profitable, and C, was saying only if it did become profitable would it be reasonable for my client to insist on his salary?
Could be saying that's somewhat stating the obvious, but yes.
Yes, but it was therefore wrong for the judge.
No, he was just saying if it becomes profitable, then they could play. I mean, but yes.
Yes.
You know, that's,
But more importantly, he wasn't advising the judge
Yeah.
that it was likely that they would. In fact,
he's saying, based on the information provided to me, I can't determine when it may become profitable.
exactly.
Yeah.
So sorry, you were saying so it was wrong for the judge to
Find that my client had an earning capacity such that the only need he needed to address was housing need. Could I then ask you to look to page 144, paragraph 91,
So this is still core bundle.
core bundle,
the judgment.
the judgment,
Thank you.
So 91.
paragraph 91, my lord. The wife contends that she needs to remain in the former matrimonial home. Whilst the standard of living enjoyed by the parties during the marriage was a good one, on the face of it, it is difficult to see how the wife's current needs as a single person extend to a 9-bedroom, 7-bathroom property. And then skipping down 2 lines. Against this, I accept that the wife has an emotional connection to the former matrimonial home to a degree that was not apparent in the evidence of the husband. Within that latter context, I am satisfied that a fair distribution of the assets can be achieved without the need to sell the matrimonial home. My lords, the conduct allegation should have informed whether or not it was reasonable for the wife to retain the matrimonial home.
Well, doesn't it really depend on the last sentence? The judge was satisfied that a fair distribution of the assets could be achieved without the need to sell it.
I'm going to come on.
If that was right, fine. But your contention is that a fair division of the assets couldn't be achieved without the need to sell the matrimonial home.
That was my next point. If you exclude Colendi, there's £12.5 million worth of liquid assets. And that's including the settle loan and the wise.
I'm just saying I'm not sure the conduct really the whether or not the matrimonial home does or doesn't need, should or shouldn't be sold, depends on the structure of the award.
It does, but the point that I'm making is that there's only £12.5 million worth of liquid assets in this case. The matrimonial home was worth £7 million, and therefore there wasn't the liquid assets in the case to enable her to stay in the matrimonial home. If the assets, however, were £14.6 million, because you've added £2.1 million that the wife, through her misconduct, alienated from this family, then it may have been viable for her to remain in the matrimonial home. But given that it had a mortgage of just shy of £1 million on it, if she was having her half share of the liquid assets, it was clearly not viable. There was no assessment by the judge of the housing need for each party or the income need for each party in that housing. And that, in my submission, is one of the fundamental building blocks of any financial remedy award to assess whether the sharing claim is going to meet that need or not. And just as my submission as to conduct were circumscribed by need, so also the sharing claim can only be assessed, or the appropriateness of how the assets are shared can only be assessed by reference to first addressing the question of need. Can I ask you to look to the authorities?
Just so that I understand it, you referred to a figure of 7 million The figure in the judge's table at 151 is just shy of 6 million.
That's net because of the 1 million mortgage.
Oh, I see. So that's the net value.
That's the net value.
And an even smaller point, the address of the matrimonial home has been incorrectly spelt throughout the judgment because there's an A. I looked up Eaton Road. It's north of the North Circular, and I doubt whether properties there are worth £6 million. So I had assumed that we were talking about NWT.
Eaton like the school, and it's close to, it's in North London.
Eaton like the school because all those properties were once owned by Eaton.
Happy school.
Yeah.
I was taking you to Wells and Wells in the authorities bundle at page 185. This is in the head note.
Hold on. Yes.
Subparagraph 1. The judge at first instance failed to identify the husband's needs and had erred in awarding the wife the bulk of those assets which were readily available at stable prices, leaving the husband with all those assets which were substantially more illiquid and risk-laden. And at 191, paragraph 26. So if the husband is to carry all the risk and all the disadvantage of the soundtrack shares, is the husband's allocation of the risk-free realisable assets fair? To answer that, it is necessary to ask whether the judge has fairly identified and provided for the husband's needs, which cannot be met by his control of the company. Certainly the tenor of the judgment is uneven. Throughout there is a concentration on the applicant's needs and upon their quantification in cash. In my citations from the judgment, I have extracted all the references to the husband's needs. The tenor of the judgment does to some degree support Mr. Poznanski's primary submission that the judge approached the case as though his only task was to quantify the wife's reasonable needs. And in my submission, that criticism applies as much to this judgment as it did to the judgment in Wells. Can I ask you then to look to Martin and Martin, also in the authorities bundle at page 111. This is my Lord Justice, Lord Moylan.
Are the authorities deliberately in random order?
My Lord, I suspect that what happened is that mine come at the start of it and my learned friends come after that.
I've come across chronological, I've come across alphabetical. These are neither.
This is, yes, this is challenging. Just testing it.
I apologise, my lords. I suspect that is the reason. We provided ours and then...
But even yours are, my lords say we start in 24 and we go back to... Anyway, it's I think it could be fairly described as chaotic.
My lord, I apologise for that chaos. So in paragraph 93...
Yes.
How is this to be applied in practice? As referred to by both King LJ and Lewison LJ, the broad choices are fix a value, 2, order the asset to be sold, 3, divide the assets in specie. However, and to repeat in my submission, this is an important point, even when the court is able to fix a value, this does not mean that that value has the same weight as the value of the other assets, such as, say, the matrimonial home. The court has to assess the weight which can be placed on the value, even when using a fixed value for the purposes of determining what award to make. This applies both to the amount and the structure of the award. Issues which are to be interconnected so that the overall allocation of the parties' assets by application of the sharing principle also affects a fair balance of risk and liquidity between the parties. Again, I emphasise this is not to mandate a particular structure, but to draw attention to the need to address this issue when the court is deciding how to exercise its discretionary powers so as to achieve an outcome which is fair to both parties. I would also add that the assessment of the weight which can be placed on evaluation is not a mathematical exercise, but a broad evaluative exercise to be undertaken by the judge. I would also add that this is not, as Mustn J suggested, to take realisation difficulties into account twice, nor, as submitted by Mr. Pointer, will perceived risk always be reflected in the valuation. The need for this approach derives from the fact that, as said by Lewis and LJ, there is a difference in quality between a value attributed to a private company and other assets. This is a relevant factor when the court is determining how to distribute those assets between the parties to achieve a fair outcome.
Sorry, just getting, sorry, it's not on what you're currently submitting. Going back to your total needs figure, you said 5 million, and you've taken us to the housing
particulars.
Housing particulars, and they were roughly three.
They were 3.85, 3.5.
So how what was the income fund that was?
So an income fund. No, they didn't particularly make submissions on the issue. And save for the fact that I said they each needed an income fund of approximately £2 million.
Right. Okay.
£2 million would provide for my clients, on assuming his pension income as well, within that analysis, £140,000 per annum. It's not quite, it's 139,980.
Gross or net?
Net.
So your submission, though, just to record, so I can record it to the judge, was that each party needed a 2 million income fund.
I said there was a floor to their needs of 5 million, such that the wife's conduct could not be properly taken account of, and that add-back was not the appropriate solution to the case.
Thank you. Sorry, yes, right. So you've taken us to Martin.
To Martin, and when, because of course the judge was taken to Wells, and I was saying to him in closing submissions, look at Wells, it's saying you have to meet needs first. I'm now going to move on to grounds 2 to 6.
So the heading can be Calendi.
Calendi.
Yes.
Could I ask you to look at 176? Sorry, I think that's a bad reference. It is a bad reference. Sorry, let me just... this is, could I ask you to look to 176 in the authorities bundle?
Which authority?
Vestige.
Which paragraph?
Paragraph 171. Paragraph 171. Unattractive as a Wells order is as an outcome for both the wife and the husband, it's hard to know what else the judge could have done given the impossibility of valuing the shares or in estimating future liquidity. And I emphasise the or in that analysis. Because although the judge felt confident in the value as ascribed to the shares by the single joint expert, the single joint expert accepted that they were illiquid and that when and whether they would become liquid was an unknown. And if I could ask you then to go back to, sorry, I've already just taken you to it, in Martin, even when able to fix a value, it does not mean that the same weight should be attached to the asset. Could I ask you to look to 181 in the same bundle?
Sorry, that was paragraph 93 again in Martin.
That was, yes, referring to
Yeah.
paragraph 92.
Sorry, what page?
181, my lord. This is Lord Justice Lewison, paragraph 195. There may be cases in which a judge is left with no alternative but to fix a value. In other cases, instead of fixing a value, a judge may order the asset to be sold, so the market will fix its real value. In yet other cases, an asset may be divided in specie. This is known in the jargon as Wells sharing. Where a judge comes to the conclusion that he can make no more than a wild guess at the value of the asset, and it is common ground that the asset in question should not be sold, Wells sharing may be the only option left. As Mr. Justice Mostyn put in GW and RW, that this was the only viable route became plain during the evidence. Both wife's accountant and husband's accountant agreed that it was impossible to attribute anything other than a wild guess as to the value of the husband's options. H would extend this uncertainty to the rest of his deferred assets. It therefore follows that a Wells sharing is the only way of achieving fairness. Indeed, it would seem to me that this should become standard fare where a case has a significant element of deferred or risk-laden assets. Or why should one party receive most of the plums, leaving the other with most of the duff? Then Lord Justice Lewison goes on to cite a slight change in tack by Mr. Justice Mostyn, referring to WM and HM, in which he said, generally speaking, Wells sharing arrangements should be a matter of last resort, as it is antithetical to the clean break. It is strongly counterintuitive in circumstances where one is dissolving the marital bond and severing as many financial ties as possible. That one should be thinking about inserting the wife as a shareholder into the husband's company. However, Wells sharing is not so objectionable that it only applies to a minority element, if it only applies to a minority element of the claimant's award. And in my submission, there are two different strains here, because in GW and RW, the relevant deferred assets were share options and the like in the company in which the husband worked, but not in which he was in control. Whereas in WM and HM, it was his life's work. And so the wife would have been a shareholder in a company controlled by the husband himself. In any event, whether those two different strains are valid, they certainly appear to be, Mr. Justice Mostyn taking different stances in relation to the issue of Wells sharing. But in my submission, there is no fixed route. If you look at 197, in our case, there were two other factors which might be said to justify Wells sharing arrangement. First, there was the impact of the PMA, which enforced its full rigour in accordance with the wife's understanding would have precluded the application of the sharing principle. Secondly, although the judge quantified the wife's needs at 22 million, she in fact came away with 51 million in copper-bottomed assets, thus giving her capital in excess of her needs of just 30 million. So again, there is a proper assessment of need. Paragraph 198. On the other hand, there is considerable force in the wife's arguments that a minority shareholding in a company which is in practice run by the husband, even if he's not a shareholder, is a very unsatisfactory outcome. Not only do commercial relations persist, even if they may not be strictly obligations, but the very nature of the underlying business structure is such that there is no clear exit route. If I could then ask you to look to 324 in the bundle, same bundle.
Hold on.
324 in the authorities.
In the authorities bundle. This is Mr. Justice Peel. Sorry, forgive me. Just checking it is Mr. Justice Peel.
Yes.
It is. It's Mr. Justice Peel in HO and TL. And if I could ask you to look at paragraph 23. Third, I suggest the reliability of valuation will depend on a number of factors, such as whether there are applicable comparables, how niche the business is, whether the business is to be valued on a net asset basis, for example, a property company, or one of the recognised income approaches such as EBITDA, and 4, the extent of the party's interest and accordingly their level of control, the extent of any third-party interest, the relevance of any shareholders' agreements, whether there is a realistic market for sale, the volatility or otherwise of the figures, the reliability of the forecasts, and whether the assumptions underpinning the valuation are seriously in dispute. The valuation of Calendly was predicated only on what venture capitalists were investing at. There was no profitability. There were no forecasts. It was simply that there had been a transaction in May 24 by investors placing $64 million into the company. And the counter argument to that raised by the husband was, yes, but since 2002 it's been seeking to raise $250 million and it has not been able to do so, such that we asserted that the valuation was fundamentally unreliable. And at paragraph 25, bottom of the paragraph, whether well sharing is practical or realistic, given that it will usually continue to tie the parties to some extent, and how to ensure a fair allocation of the resources in any given case. Sorry, I've cut half a sentence. Fifth, whether the business should be retained by one party or sold and divided in specie will depend on the facts of each case. Relevant features will include whether the business was founded during the marriage or pre-owned, whether it has its origins in one party's non-marital wealth, and whether...
Yes, because if you read 24, paragraph 24, fourth, in practice the choices for the court will be, and then he quotes from Martin.
Yes.
It looks though he's saying those are a sort of separate, distinct options, which I'm not sure is a fair reading of Martin. In other words, you pick one route and go down. You can fix a value, and you can also divide the asset in specie. They're not alternatives.
They're not alternatives at all, and indeed that's why...
It looks as though in 24 he is possibly treating them as alternatives, but I think when you read 25, you realise he isn't, because he's saying whether or not it's sold, retained or divided will depend on the facts of each case.
Exactly, and that's my point, that the learned judge in our case seemed to consider himself constrained by the concept of well sharing being a last resort, and the circumstances, as I'm going to come on to demonstrate, in which the parties came to own those shares, whereas in my submission the issue of whether or not you should well share is defined not by any pre-existing polemic for or against it. It merely depends on the circumstances of each individual case as to whether it is appropriate. And could I ask you then to look to the supplemental bundle at paragraph 162. Apparently 170 in your bundles. At 162B.
Sorry, which internal page?
One internal internal 12.
Yes, okay. So, and which line?
At A, Mr. Thorpe,
Yes.
I submit that what the wife was doing was putting up more barriers to settlement. Ultimately, we have the permission of the founder to make her an equal beneficiary under the trust. When at huge expense, the letters padding back and forth over the summer, where the wife is analysing the shareholders' agreement and the trust agreement saying, you cannot do this, it is wrong. And eventually we say, whatever the point is, you can get an equal share, so we write another open offer, and that is the genesis of the structure of the contingent lump sum. If I could ask your lordship...
You mean that offer?
That offer, it was because the wife was saying we couldn't transfer the beneficial interest in the shares to her, or the legal and beneficial interest in the shares to her. If I could ask you to look at 105 in the same bundle.
And the judge in the judgment seems to, or says that that was the position that ultimately both parties took.
That's not. I'm going to come on to it.
Okay.
But the reason for that is because it's a taxable event in America if we transfer the shares to her, and the wife would have had to submit to what we refer to as the Section 6013G provisions,
Right.
which enable the transfer to take place on a tax-free basis. But the wife has to apply in the States to submit to their taxation jurisdiction for so long as they are married. And the reason why we have not got decree absolute in this case is because we have preserved her ability to make that application, because we would prefer her to have her shares independently of us, but in order to do that, she has to submit to that jurisdiction. So the whole structure of the contingent lump sum was caused not by an inability to transfer the beneficial interest in the shares. It was just because the wife would not submit to the IRS jurisdiction solely for the purposes of transferring marital assets. And I'm going to come on and demonstrate that in the judgment. At 105 in the bundle is the cross-examination of the husband.
The supplemental bundle.
The supplemental bundle.
Can you, in case the page differences are different, can you give us...
Internal 29. At A, this is
Yes.
Perhaps it's better to start at the bottom of page 28. Question, I just want you to agree with me that Mrs. Culligan is not a permitted transferee under the shareholders' agreement. Yes, by all means, Mr. Culligan. Yes, by all means, comment, Mr. Culligan. But to the extent, first of all, if it were a deemed transfer, when you are going from yourself to yourself, that would be one question I would ask. Secondly, if it turns out that Mr. Techman has a right of first refusal, but say he bids, 10p per share, then Diane could actually pay, 25% more than that bid in order to complete the transfer. So she could say, I will bid 12.5p per share. And that is her paying herself as consideration to exceed Mr. Techman's bids. In other words, it would just be, in effect, Mr. Techman's right of first refusal has no practical impact on Diane to transfer to herself. And if I could ask you to look to page 17 of the same bundle. Article 12.6. If the selling shareholder does not wish to accept the offer, It shall send to, sorry, that's the founder's offer for the shares. It shall send to the founder a notice in writing declining the offer. If the selling shareholder fails to send any notice to the founder within the offer acceptance period, they shall be deemed to have declined the offer. In cases where the selling shareholders have declined or deemed to have declined the offer, the selling shareholder shall be entitled for a period of 30 business days from the date on which such notice is issued, or if no notice is issued, within the offer acceptance period, 30 business days from the expiry of the offer acceptance period, to sell the offer shares to third parties, provided that the price per share offered by the third party offeror is higher than 125% of the offer price, namely the offer price by the founder. So the effect of that is that if the wife wishes to transfer her beneficial ownership from herself to her legal ownership, she has to offer the right of preemption to the founder. And if the founder does make an offer, which we consider highly unlikely, but if he made an offer, the wife would have to offer 25% more. And the effect of that means that she could transfer the shares from her beneficial ownership to her legal ownership. And my client's case was, I have obtained the permission of Mr. Teckerman to transfer the beneficial ownership to you. And the reason for that is because the settle shareholders were all required to come under the umbrella of one company, save for Citigroup, because my client's evidence was that Colendi liked having Citigroup on the list of shareholders, but didn't want to have lots of minor shareholders on that shareholders register. And so the deal with Settle was that the Settle shareholders all came under a nominee company, and their ownership was pursuant to that umbrella of the nominee company, such that he only has a beneficial interest in the shares, the legal interest being owed by the nominee company. The point that my client was making to Ms. Faginato was, it's easy for the wife to extract herself from that nominee ownership structure because of the terms of the articles, which enable her to effectively bid up on the founder's offer, but because she's paying herself, it doesn't matter. She can bid up. And if I could ask you to look to the supplemental bundle at page 92. The issues, whilst our client maintains the valuation, this is, sorry, his open offer, his second open offer, his first open offer was that the shares should come across to the wife. His second open offer, when she put up the objections that she did, was, whilst our client maintains the value of Mr. Rodwell is nonsensical, he recognises that the speculative value applied by venture capitalists on buying into the company
Sorry, where are you reading?
Sorry, forgive me, my lord. I'm on page 92 of the supplemental bundle.
Yeah, but where?
Paragraph 1.
Thank you.
Whilst our client maintains the valuation of Mr. Rodwell is nonsensical, he recognises that the speculative value applied by venture capitalists on buying into the company is one basis upon which the company could be valued. It is not a valuation that he accepts, however, given there is no market for the shares, that speculators are prepared to pay $2 per share if the funding round completes successfully, which it notably remains ongoing some 1 year after the report, does not mean that there is a market for his shares at that price. Our client proposes that your client should receive a contingent lump sum to reflect 50% of our client's shares on terms set out at passage number 6 below. Our client also remains willing to provide the necessary undertakings which would offer your client adequate security, and we attach a draft of these for your convenience. If I could then ask you to look in page 122 in the core bundle. this is in the judgment where the learned judge is setting out the advice of Mr. Pannell, the tax expert, paragraph 32, fourth line down. Second, with respect to US tax due on UK property transfers between the parties, provided the parties remain married on the last day of the tax year, an election can be made under US tax code IRC 6013G, which would have the result that transfers of UK property from the husband to the wife during the period of the election would not give rise to a US tax charge on transfers. And then if I could ask you to scroll down to page 145, paragraph 95. On the expert tax advice before the court, an election pursuant to the US Tax Advice Code 6013G would have the result that transfers of UK property from the husband to the wife during the period of election would not give rise to US tax liability. And at the bottom of the paragraph, I am satisfied that the wife is not prepared to mitigate the tax liability by making an election. Sorry, I am satisfied that if the wife is not prepared to mitigate the tax liability by making an election, then she must bear the additional tax burden that results from taking that position in the manner described above. That subsequently became limited to the tax on transfer of the matrimonial home, which was approximately £95,000. But there you see that it was considered by the court reasonable for her to have made that election. She refused to do so. Because of that refusal to do so, my client was obliged to offer the contingent lump sum as the alternative route. His preference has always been to separate the parties through separating the shareholding in Coulson. If I could ask you to look in the supplemental bundle to page 77.
Give me the page reference.
Sorry, my lord, 77 of the supplemental bundle. This is the trust agreement in relation to the husband, but it applies in relation to all the former settle shareholders apart from City. And you see here Coulson settle nominees and Coulson Holdings Limited. The beneficiary was at little b, whereas the beneficiary was a shareholder in Settle, and in exchange for selling those shares to the company is entitled to a beneficial interest in 12,933 shares. So the wife would, if she submitted to 6013G, have a beneficial interest in the shares. She would have a trust agreement of a similar nature. She would have to adhere to the articles and the shareholders' agreement of the Coulson Holdings Group generally, but they would be two entirely separate shareholders in a company that was not controlled by my client. Although he continued to work for Settle, he was not on the board of Coulson. And in my submission, this is made plain if you look to the core bundle at page 150. At the bottom of paragraph 110, this is the judge's explanation as to why he has alighted on the course that he has. At the bottom of the paragraph, converted his shareholding in Settle Limited, representing close to half the matrimonial assets, into an illiquid minority interest in a multinational corporation. And that is what it is. It's Colendi. It's a multinational corporation not under the control of my client, on which he does not sit on the board. Can I just invite you to look to the supplemental bundle at page 204.
Which internal page?
Internal page 54.
That's our 212. I think.
So,
Is that right? Internal page 54.
internal page 54 at the top of the page, A.
Yes.
Miss Faginato, she did not want, in this case, to take the majority of her award in the form of an amorphous interest in Colendi. So, yes, May of 23, a 2-page statement filed, a conduct statement. That is a fact in this case, namely her shield to having half the Colendi shares was her conduct argument. And that is further confirmed by my learned friend, Miss Faginato, at page 205A. Miss Faginato. Sorry, forgive
yes.
me.
Which?
Internal 55. Forgive me.
Thank you. Yes.
At A, Miss Faginato, the husband's behaviour since this litigation has started is such that it would be inappropriate to divide the assets in the way that he seeks. Candidly, my lord, it is run as a shield to the husband saying, you have half my shares in Colendi. If you could then, my lords, turn in the core bundle to page 133. Paragraph 53. Each party also alleges that the other has been guilty of non-disclosure in the circumstances I have described, although, as I have noted, the wife does not assert that at the date of final hearing there are hidden assets, nor does she invite the court to draw inferences to that effect as a result of any non-disclosure by the husband. He goes on at page 146. To say, first of all, at paragraph 97, bottom of, so just above 98, last sentence, I'm not satisfied that the husband's conduct of his finances and what the wife contends was a secretive and unilateral matter constitutes conduct that it would be inequitable to ignore for the purposes of section 25. So my first point is, if it's not conduct, then we know from what Mr. Justice Peel said in Setskov that you can't have conduct by the back door, and that has been long established since Miller, when Miller went to the Supreme Court in Miller and McFarland. And at paragraph 99, for the foregoing reasons, I decline to take into account the matters of alleged conduct relied upon by the wife pursuant to 25(1)(g). None are matters that it would be inequitable for the court to ignore when determining the fair distribution of the matrimonial assets. With respect to the allegations of non-disclosure and wider litigation relied on by the wife, I am satisfied that it is appropriate to deal with those matters when the court comes to deal with costs, As I've noted, this is not a case where the wife contends that there exists assets hidden from the court as at the date of the final hearing. In the circumstances, I am satisfied that the matters complained of constitute delayed or late disclosure, which may sound in increased costs. And
So your submission is conduct was said to be a shield. The judge rejected conduct, therefore the shield falls away.
the shield falls away. And further, at 164 in the core bundle, this is the judgment on costs. And at paragraph 18, he sets out the wife's misconduct. And at 19, he says here, the learned judge says here, second, whilst Miss Faginato submits that the court did not make a conduct finding against the wife in respect of the ELSA transaction. My learned friend cites this in his skeleton argument. It's not the court saying that it did not constitute conduct, it's Miss Faginato saying it did not constitute conduct. The court did find that it was conduct, and it added 1.6 million back into the asset pot that the wife sought to exclude. And if I could then invite you to scroll down to 167. Paragraph 26, the court, in light of the wife's conduct, orders that she should make a contribution to the conduct. And give me I'll move on. I can't find the quote that I was looking for. If I could then ask you to look at core bundle page 119. Mr. Rodwell did not consider it appropriate to, sorry, this is paragraph 20. Mr. Rodwell did not consider it appropriate to apply a discount when assessing the valuation of the husband's shareholding in circumstances where it is likely that interests acquired in the current funding round are comparable to the husband's interest in terms of size, rights, restrictions. Then at the bottom of the page, in the circumstances, Mr. Rodwell considered that from a valuer's perspective, as opposed to any discount a court might apply.
Sorry, where's the...
Sorry, last sentence of paragraph 20.
Oh, sorry, yes, okay, thank you. Yes.
In the circumstances, Mr. Rodwell considered that from a valuer's perspective, as opposed to any discount a court might apply due to the illiquid nature of the asset, the value of £2 per share already had a discount for illiquidity price. Finally, Mr. Rodwell considered that the husband will not at present be able to extract any liquid capital from Colendi in circumstances where it is loss-making, currently seeking to raise capital, suggesting little or no surplus liquidity, and the husband not being in a position as a minority shareholder to compel the company to distribute any existing cash balance. He goes on to cite at the bottom of the paragraph that Settle has been loss-making and Colendi has had to support Settle with cash injections on an almost monthly basis. Could I then ask you to look at page 147 of the same bundle? paragraph 100, so just above 101. This presents a particular challenge in this case in circumstances where close to half the matrimonial assets available for distribution in the form of the husband's Cullendi holding are illiquid and carry with them a level of risk. Those circumstances lead to the need in this case to consider the question of wealth sharing. In fact, it wasn't almost half, it was more than half. It was 13.7 out of 26. Could I ask you then to look to page 137. This is where the learned judge addresses the question of discount. I likewise accept Mr. Rodwell's evidence that
Sorry, which paragraph?
Sorry,
65.
65.
Yes.
I accept Mr. Rodwell's evidence with respect to the question of whether a discount should be applied to the valuation. I acknowledge the valuation of an asset is an estimate of what it will sell for now, and that if it is perceived as being hard to realise, its value will be discounted to reflect that difficulty. It's further the case that the husband's Cullendi shares are illiquid and are shares in a private company. Against this, I accept Mr. Rodwell's expert opinion that it is not appropriate to apply a further discount to his valuation of the husband's Cullendi holding in circumstances where investors willing to pay $2 per share in May 24 were aware of the restrictions on liquidity. And scrolling down, or coming down to 5 pages from the bottom of this paragraph, 5 lines from the bottom of this paragraph, finally, notwithstanding Mr. Thorpe's urging, I'm not persuaded that the fact that the husband is involved in divorce proceedings is relevant to the question of discount as evaluated by Mr. Rodwell. An investor would ordinarily not take into account the marital status of other investors when deciding. That wasn't my point. My point was, is it realisable for him as a husband? But in any event, the judge goes on to say, the question of whether the court may ascribe a lower value to the asset in the distribution exercise is a separate issue. And in my submission, that is not an issue which the judge then went on to deal with. If you could look at 148, same bundle, paragraph 104. The view of the Court of Appeal in Vestige and that wealth sharing will be the last resort and should only compromise a minority element of the award was expressed in the context of illiquid or risk-laden assets that could not be valued accurately or at all. And then he goes on to cite Mr. Justice Mostyn. And further, the earlier comments of Mr. Mostyn QC highlight the importance when contemplating wealth sharing of remembering that considerations of fairness operate both ways. It may also be onerous for the party in whose name the illiquid or risky asset is held to be left with all or a greater share of that asset. The fairness of that outcome must also be considered within this context if the illiquid or risk-laden asset has been built up from matrimonial funds in an open manner during the course of the marriage and is capable of being reliably valued, there may be a stronger argument for the risk and potential reward to be shared more equally. To this end, the circumstances by which the asset in question came to be illiquid or risky and the reliability of any valuation that can be achieved in respect of it may also be relevant.
Can I go back to the first sentence? The view of the Court of Appeal investigates that wells will be a last resort and should only comprise a minority element. Those were, in fact, as you've shown us, extracts from first instance decisions of Mr. Justice Mostyn.
They were.
And he doesn't actually say that it should only comprise. He says that it's not so objectionable. I suppose it could be said that in quoting them, quoting from them, Lord Justice Lewison could be taken to have agreed with them, but he doesn't expressly. He doesn't express any view about them.
But he also, sorry, forgive me.
But I think your submission anyway is that it's a broader analysis than that, and it's wrong to say that well sharing is a last resort? Because you said there shouldn't be any.
There should be no straitjacket on it. But also, to take your point, my lord, Lord Justice Lewison also cites Mr. Justice Mossin in GW and RW, where he says it should be standard fare. So he's not endorsing either approach. He's merely setting out the history. And Mr. Justice Mossin takes two alternative approaches. And in my submission, there is logic to Mr. Justice Mossin's position, although I don't accept the straitjacket in any event, because Mr. Justice Mossin in GR and RW was dealing with an asset which was not within the control of the husband, and in WM and HM it was.
If you just take out, if you look at the words last resort and standard fare, they're inconsistent.
They're inconsistent.
But you're saying that looked at in the context of the particular case,
you could argue there's consistency.
Well, yes.
I'm not attempting to.
No.
My primary submission is there should be no tram lines that require a court to take one route or another, and that was what Mr. Justice Peel held in Hotel.
But the other submission you make is that in quoting them, Lord Justice Lewison was setting out sort of aspects of the history, and it would be surprising if he was endorsing both when they seem to be inconsistent.
Exactly. Could I then ask you to look to 105, which is where the judge, paragraph 105, page 148 for me, I hope it's, yes, 148 for yourselves as well. Last line of the paragraph, last line on the page 148, ultimately both parties did not appear to dispute that at the very least there was no certainty that this could be achieved in a manner that would result in the wife securing unencumbered legal and beneficial title to those shares. And I've taken you to the cross-examination on that point. In my submission, Ms. Faginato did not demonstrate that my client was wrong in his assessment of the impact of the articles. Within this context, the parties ultimately did not appear to dispute that insofar as the court was required to distribute the matrimonial asset that now comprised the husband's Kalendi shareholding, this would have to be achieved by way of a contingent lump sum of the husband's net receipt upon the sale of his Kalendi shares, coupled with an undertaking to notify the wife of any such sale and to transfer the relevant share net of net proceeds to the wife within 5 working days of receipt. The husband taking his position following the refusal of the wife to make an election under US Tax Code IRC 6013G. And there you have the finding that the only motivation for the contingent lump sum was the wife's refusal to submit to that methodology, that tax regime. If I could then ask you to look at 107, sorry. In my submission, in this case, discounting wouldn't have been fair. I'm not going to take you to it, but I set it out in my skeleton argument that even if you discounted by 45% and awarded the wife 30% of the shares, there would still be an imbalance of £1.2 million between the parties' positions. And I don't propose to repeat that here. If I could then ask you to look at 149.
Which is where we are.
Which is yes. Where you are.
Which paragraph?
Sorry, just bear with me. Paragraph 108. The contingent lump sum dependent on the Kalendi holding would have a number of disadvantages for the wife associated with well sharing. It would prevent a clean break at this point in time. If I pause there and say, not if the wife submitted to the American tax regime to enable us to transfer the shares across to her. It would, requiring that which a clean break seeks to avoid, namely two people who have fallen out having to continue to cooperate closely in respect to financial matters, would leave the wife dependent on an illiquid asset to which risk attaches and in which it is difficult to deal, would place the wife in a position in which it is difficult to provide her with any solid protection with respect to a contingent lump sum comprising not insignificant element of her award, and would leave the wife with a lack of certainty in respect to when Coulson shares could not be realised and potential future costs consequent thereon. Then if you scroll, the learned judge doesn't therefore address the fact that that is of the wife's own making because she won't submit to the tax scheme. And at 109, against this, I have noted in circumstances where it is onerous for the party in whose name the liquid or risky asset to be held is left with all or greater share of that asset, the fairness of that outcome must also be considered. And in my submission, the judge doesn't conduct that analysis for my client. He goes into it in depth in relation to the wife's position, but not in relation to the husband's. And he gives his explanation in this paragraph. On the evidence before the court, I am satisfied that the wife was not consulted by the husband before he dealt in the way that he did with the substantial matrimonial asset that was settled limited, rendering the matrimonial asset illiquid and subject to increased risk. Well, the single joint expert had confirmed that Settle had run out of money, that my client had had to lend it £200,000 to make the November 23 wage bill of that company. That debt remains outstanding to my client and is the Settle loan to which we have referred. His evidence was that he would have to put it into administration because he could not afford to run it. The single joint expert's evidence was that Coulson were having to support it at the tune of £50,000 per month. And the judge found that my client was not controlling about money, but at the time when the wife was looking for money to be injected into ELSA, he no longer had the money to do so. So Settle was, yes, 40% owned by the husband, but it was on the verge of administration. And my client managed, he says, to snatch victory from the jaws of defeat by agreeing the share swap with Coulson, which has a notional value of £19 million for the parties, £40 million for the Settle shares, shared amongst all the shareholders. But it is quite wrong to assert, as the judge does, that his not consulting the wife about that action justifies the judge lumbering my client with the majority of the Coulson shares. And if I could then ask you to keep reading on this paragraph. However, the Coulson shares comprise an asset that was built up within the marriage from other matrimonial assets, in the first instance Bitcoin and thereafter Settle, while there was a dispute as to the extent to which it was necessary for the deal with Coulson to be structured in the way that it was, in circumstances where, contrary to the husband's justification for a nominee holding, multiple small shareholders are listed on the Coulson register, and other companies which have invested by way of shares owned directly. If I can just pause there. He does not find that my client was wrong to assert that the Settle shareholders had to go into the nominee structure, save for City. He merely says that the dispute was there. Going on, the wife did not appear to contend that the husband had structured the deal with Coulson in a deliberate attempt to defeat the wife's claim. Indeed, as I have noted in cross-examination, the wife was keen to emphasise that she had not used the word dishonest to frame her contention with respect to the husband's approach. Finally, as I have already observed, I'm satisfied that fairness demands that the husband have sufficient liquid assets after he's cleared the liabilities for which he's responsible to rehouse himself. And then the next paragraph, in my judgment, the combined effect of the matters set out above is that there must be some sharing of Coulson asset, although the wife's share should be kept to the minimum amount required to ensure fidelity to the principle of fairness. In addition to the difficulties inherent in wealth sharing summarised above, I am satisfied that it is fair for the husband to bear the larger share of the consequences of having, without consulting the wife, converted his shareholding in Settle, representing to close to half the matrimonial assets, into an illiquid minority interest in a multinational corporation.
Can you enlighten me? What is supposed to be the legal significance of the absence of consultation?
Well, we asserted that there was none in our skeleton argument. We said that they have separate property regimes, that it wasn't a secret, the wife knew about it 6 months in advance, and she could have stopped it if she had asserted it was the wrong thing to do. But most importantly, having found that this did not constitute conduct, it was wrong then for this to be the justification for lumbering the husband with 73% of his award in an illiquid, non-profit making company. And in my submission there, the judge has plainly gone wrong.
So what your submission is, this is conduct by the back door?
It's conduct by the back door. But also, if you consider that he has found conduct in relation to the wife. He has found that she did fail to provide us with disclosure of the ELSA deal. He has found that when we unpicked that deal, it was a construct to apportion a third of the proceeds of sale as income rather than the capital value of the asset that she was selling, in order to say that it was future income and post-separation accrual. So the very justification for leaving us with 73% of our award in illiquid shares was our apparent secrecy, which he has discounted. He has found for the wife's secrecy and her dishonesty, and yet, for some reason that is inexplicable and is not justified on the law, he has left us in this position.
But your primary factual submission is that the judge seems to have viewed this as a deal that should be taken against your client, when your case is actually he should be applauded for doing this, because he converted what was a very, possibly worth nothing into something that's worth potentially a lot.
And that also goes to the fragility of the valuation of 19 million, because although Kalendi paid for Settle in shares, Settle was on the verge of administration, not making a profit, having never made a profit. And so they've agreed a notional value for those shares between themselves and announced it to the market. And Settle has continued on it, Kalendi has continued on its attempt to raise money in the market, using the valuations that it has agreed between itself and Settle for this element of its overall value. But really, there is no hard value there for the court to rely on. And it is a chimera of a valuation which demonstrates in any valuation of a private company how hard it is to rely on that valuation, but often that is on the basis of profits, assets.
I understand, but just to pursue what I'm saying, at the top of that page 150, the judge says that the wife was not consulted before he dealt with the shares with the asset, rendering it illiquid and subject to increased risk. And your submission is that is not a sustainable finding on the evidence.
Is not a sustainable.
It was illiquid anyway, and there's no evidence that it's now subject to increased risk, given your client's evidence as to the state of Settle at the time this happened.
Exactly, and that evidence was supported by the single joint expert. I can take you to his evidence if that would assist, but he confirms that Settle was not making a profit, has never made a profit, and that subsequent to the sale is having to be propped up by Kalendi to the tune of £50,000 a month.
Right.
Which my client simply didn't have at that time to continue to support that venture.
Now, what the judge says in paragraph 110 is he relies on that factor, the lack of consultation, and he also refers to, in addition to the difficulties inherent in Wells sharing, and I think you've made your submissions in respect of that. the circumstances of this case, having regard to it, were not such as to support the conclusion that the division of the Colendi shares would create the difficulties inherent in wealth sharing in this case.
That's right. Sorry, was that
No, there was an observation. Not a question.
I wonder whether it was a question.
No, did my voice go up or down at the end of it, implying a question? It wasn't. It was
the inquiry manner in which
it was more me collecting my thoughts, but thank you, openly.
In terms of a solution, in the event that your lordships were with me, in my submission, my learned friend is right that we have not applied for a stay, but of course an appeal is not a justification for a stay. And we say that the imbalance is 20% of the value of Colendi. And Colendi is valued by Mr. Justice MacDonald at 13.718 million. 20% of that is 2.743 million, which expressed as a percentage of the net value of the matrimonial home. Now, if I just clarify net value, I mean net value less cost of sale at 3%. I'm excluding the mortgage because the wife may well have paid it off. She was given sufficient capital so that she could have paid it off, or she may have run it, but it is only right that it should be expressed as the net value deducting costs of sale would equate to 40.406% up to a value of 7 million. And in the event that it were to achieve more than 7 million, anything above that should be shared 50% equally. But in my submission, the differential there set out, namely 2.743 million, demonstrates the unfairness of Mr. Justice MacDonald's leaving us with that much.
Wait a minute, I'm not quite sure. Your submission is that if we find the judge has gone wrong for the reasons you've advanced, you're inviting us to redo the
to exercise
award.
Your discretion.
Right,
and
to remake it.
The parties have transferred lots of assets between themselves, so you have seen the property investments numbers, I think 7 or 8 different investments. Those are all transfers that have taken place.
Right.
And therefore, if your lordships were with me that Mr. Justice MacDonald has gone wrong and you were to exercise your discretion afresh, the simple way in which to do that in my submission is to say that he has awarded us 70% of the Colendi shares rather than 50% of the Colendi shares. So the differential is 20%. 20% of 13.718 million is equivalent to 2.743,600,000.
Yes.
Which expressed as a percentage of the net value of the matrimonial home, excluding the mortgage, i.e. just deducting costs of sale, so 6.79 million for the net value, deducting 210,000 as costs of sale, equals 40.406%.
And what? Okay. So your submission is that the division of the Colendi share should remain as it is?
No, that
yes.
There would be, the wife would have 50% of the Colendi shares.
That's what I thought. Okay. So
therefore, an extra 20% would come across to her. On the judge's valuation of that, that is equivalent to 2.436 million.
So is it essentially you're saying there should be an equal division of the assets as they're set out on page, in paragraph 112 of the judgment?
Yes, an equal sharing. So if you look to my notice of appeal, although I have complained of the unfairness in not addressing the issue of the wife's conduct and how that should be addressed, at page 8 in the bundle, hoping to persuade your lordships of the fairness of my case, I have not sought to invite you to impose conduct into the solution. In my submission, there should be an equal division of all the assets, including risk-laden and non-risk-laden. and therefore,
And is the sorry to interrupt you?
Sorry.
Is this the result for which you're contending, incorporating the submissions you've made about the settled loan and the 750,000 tax?
yes, it goes. Sorry, the 750,000 deferred
Yes.
interest. Yes, my complaint about those is they're further examples of the judge having gone wrong. They're further examples of the judge having not listened to us and not being fair to us.
But you say what you're proposing on page 8 would be fair, incorporating all your case, all aspects of your case.
All aspects of my case.
I understand.
As it were, I'm underselling my case.
And it's a division of the proceeds of sale on the assumption that the mortgage has been paid off, or on the assumption of 5.9 million
Sorry,
net value.
forgive me. I can see there that sale of the FMH and equal division of the proceeds of sale is not quite what I'm saying, because when analysing because we haven't applied for a stay, so lots of transfers have already taken place.
Yes.
The simplest solution is to transfer 20% of Kalendi across to the wife. We would invite the court to say that she should have the beneficial interest of the full 50%, so that they are not tied together by the contingent lump sum, but that would require her to submit to the US tax regime. And if she won't, then there is nothing that this court in my submission can do to oblige her to do that.
Right.
And therefore we are left with the contingent lump sum, in which case she would have a contingent lump sum of 50% of the value of the shares. And in order to rectify that, 40 points.
So you're saying it's 2.74 roughly million of the net proceeds of sale?
Yes.
Okay.
Up to 7 million, because it was our case at trial that it might well sell for more than 7 million. It was one of our arguments in support of the
that
sale.
was then.
That was then.
I don't imagine that is a realistic submission now.
You may be right,
From my
Lord.
knowledge of the property market in North London, I
it's-
would be surprised if that
But,
was
my Lord, you have a superior knowledge to mine. My Lords, is there any issue that I haven't addressed that you would like me to address?
Do you want anything? So, no. Would it be convenient to stop now? Would it was 5? Have I read the time right?
5 to 1 month.
5 to 1. Would you mind stopping a little bit early? And we'll start again at 2 o'clock.